everyone. My name is Anna Guillard-Sazhko, and I'm an associate at Paris office of Shearman Sterling. I'm also a member of the organizing committee of the Eastern European Dispute Resolution Forum. And today it's my pleasure to welcome with us Jean Burd to a quick and honest interview to discuss quite an exciting topic of the enforcement of arbitral awards from a US perspective. Jean is joining us from Washington, D.C. He is a partner with FisherBroyles, a distributed law firm with offices in 26 jurisdictions in the United States and London. Jean's practice focuses on international disputes, including arbitration and international litigation in the US courts. Jean assists clients in cases involving recognition and enforcement of international arbitration awards and foreign judgments. He has extensive experience with cases involving foreign states and foreign state-owned enterprises. That's why our today's interview will be devoted to the topic of the enforcement of arbitral awards against states and state-owned enterprises.
Thank you, Anna. I'll be delighted to share with you and our listeners aspects of enforcement of arbitration awards in the United States, and in particular, arbitration awards against states and state-owned enterprises. Thank you.
Let's talk now about the enforcement of arbitral awards. Let's say there is an award against a state or state-owned company. Why would you advise to enforce in the United States?
I think the simple answer to that question is that many states, and probably most of the states, they have some type of assets in the United States. And these assets could consist of financial deposits. This asset could consist of, for example, bonds. Every state or most of the states, they issue bonds. And if these bonds are denominated in US dollars, in many cases, US banks are those who manage these bonds and who affect payments to the states and to the bondholders. So this is certainly one of the assets that claimants consider as the asset that they can go after. In addition, there are many states, they have counterparties to their state agencies and instrumentalities in the United States. There are contractual relationships that can be also targeted by claimants in the enforcement proceedings. So all these provide the ability and the interest of claimants to enforce arbitration awards against states and state-owned enterprises in the United States.
Can you share with us any examples of cases in which the claimants were able to execute the awards against states in the United States?
In many cases involving enforcement and recognition of arbitration awards against states, the states decided to settle claims against them after the claimants were successful in their enforcement efforts in the United States. There are a number of cases, for example, involving Venezuela, where Venezuela eventually gave up and decided to pay the investors after the courts, US courts issued judgments or prevented Venezuela or decided or dismissed Venezuela challenges to the enforcement. Another interesting case is the case against the Republic of Georgia that was brought by Mr. Fox, who eventually prevailed in his proceedings and his claim in the US courts, and then Georgia decided to settle with him after that. So I think to answer your questions, there are many cases where the efforts of the investors to enforce awards in the United States led to the resolution of the case by way of settlement.
Have you ever participated in a settlement, in a negotiation regarding the awards?
I have participated in settlement negotiations, not in the state-related cases, but certainly in the cases involving commercial arbitration awards. And of course, after the US court issues a judgment enforcing the award or issues the attachment of assets, that basically puts the respondent in the position where respondent doesn't have too many choices. Of course, the claimant still has some, there's still time factor that would need to be taken into account on behalf of the claimant, but still the fact that the US court issues a judgment, the fact that there's an attachment or injunction or freezing of assets certainly puts the respondent in the position where respondent is forced to engage in negotiations.
How long usually last these negotiations?
It really depends. It may take several weeks to several months, or even a little longer. It all depends on the specific terms of the negotiations. It all depends on the specific position of the parties, and there, certainly on the strengths of the legal position of the parties as well.
What is a typical procedure for the enforcement of an arbitral award in the US?
The United States was the party to the New York Convention for the Enforcement of Arbitration Awards. And there are laws in the United States that provides that US courts obligated to enforce arbitration awards that are subject to the convention. The procedure is pretty straightforward. The successful claimant in the arbitration is required to file a petition with the court in the United States to recognize and enforce arbitration award and serve this petition. That's important because the service needs to be done. I understand that in some countries, in order to recognize the arbitration award, you don't need to do service initially to give a notice to the opposing party, but in the United States, it is mandatory. And then the opposing party, the respondent, has the right to raise objections. And mostly the objections are limited to the objections that are set forth in the Article 5 of the New York Convention. U.S. courts typically would not consider any objections on the merits, although there are some exceptions. There are some courts in the United States that consider the objections to the enforcement that is based on the manifest disregard of law. And that's something that's been one of the issues in the recent case in New York, where Southern District of New York actually refused to enforce the award, New York Convention award, that based on the manifest disregard of a law. These cases are extremely rare, especially with respect to international commercial arbitration, but the arbitrator still needs to be aware that such cases exist and such grounds for refusal to recognize the word exist. Then the court decides on the objections, and if the court decides to disregard the objections, then the court issues a U.S. court judgment. That then this U.S. court judgment can be enforced in accordance with U.S. law.
Have you ever heard of a case when somebody tried to enforce an award against the United States in the United States?
Well, that's certainly an interesting question. To my knowledge, there were no arbitration awards against the United States that there were attempts to enforce in the United States. Especially the investment arbitration awards. But there is actually a case that was recently filed by Ukrainian businessmen to the arbitration claim that was initiated by Ukrainian businessmen against the United States. Now, that arbitration claim is still been it's still in the arbitration stage or pre-arbitration stage, so it's unclear whether it would be enforceable or enforced in the United States. But I don't believe historically there are cases like that. But just to give you an idea, United States has a special law that actually allows bringing claims against the United States itself. And so the investor, for example, there's an investor who believes that the United States, his rights in the United States were infringed upon. That investor can actually bring a case in the United States courts against the United States. Now, of course, that may not be, let's put it this way, some investors may not be satisfied with the right to bring a case in the US court against the United States, but typically US courts, they do hear a lot of cases against the United States itself that are brought by domestic parties based on certain specific US laws, where contractual cases. There are numerous contractual cases against the United States by the suppliers, by the service providers that provide services to the United States that are brought in U.S. courts. So that is typically, and United States does not prevail in all of these cases. So let's put it this way. So I would suggest that definitely if there is a foreign investor that has a claim against the United States, a potential claim against the United States, it might be a more effective route to bring a claim in a court in the United States rather than going through the arbitration process.
If you represent a foreign state, what are the best defenses that can be presented against the enforcement?
First and the foremost, the most important is to understand that United States has a law that is called Foreign Sovereign Immunities Act that actually makes states immune from lawsuits in US courts unless certain specific exceptions apply. And these exceptions are limited in terms of circumstances as to when they apply. Of course, there is a specific exception for enforcement of arbitration awards, but this exception to enforcement can only apply if the award has certain specific parameters. Primarily, it has to be an award that is subject to an international convention. For example, a New York Convention. The second, and it's important also, is under the Foreign Sovereign Immunities Act, the service of process is very detailed. And the states, they need to be aware of the procedures for service of process. And I know there are a number of cases where states did not raise objections to the service of process, even though the service of process was not made properly. And that's very important. So the states, lawyers who represent the states, they need to be aware of these requirements. Third, and also important consideration is jurisdiction. In some cases, there are issues whether whether the arbitrators had jurisdiction to hear the case, where for example, there was an arbitration agreement, there was not arbitration agreement. So the U.S. courts would also look into these issues, and this is certainly one of the issues that is often raised by foreign states when awards are enforced in the United States against foreign states. There are also certain defenses that apply in cases where the respondent is not a state-owned company. For example, in the United States Constitution provides the defense of personal jurisdiction. Basically, United States Constitution limits personal jurisdiction of US courts to certain specific circumstances. There has to be some type of due process, what we call due process. So if a foreign state company, even if it's a state-owned company, it's still subject to, it has right to due process under the US Constitution. And this defense must be considered. In addition to that, there is also defense of forum nonconvenience that's been applied by some courts, not it's disputable whether it's legally applicable or not to the enforcement of arbitration awards, but nevertheless, it has been applied by some courts. And lastly, what is also very important is that in addition to jurisdictional immunities or jurisdictional exceptions from jurisdictional immunity, there are separate exceptions to immunity from execution of judgment. So even if successful claimant obtains a judgment, there are separate and additional immunity from execution, an exception from execution that applies. So that's just additional hurdle for the claimant and additional opportunity to raise defenses for a foreign state or a state-owned company.
Are there any recent cases involving parties from the former Soviet Union?
There are a couple of cases that come to mind. One case is a Stati versus Republic of Kazakhstan. That's the case where an arbitration award was issued against the Republic of Kazakhstan in the amount of over $500 million in favor of Moldovan investors. And the investors filed to recognize this award in the United States, in the Washington, D.C., in the district court for the District of Columbia. And they eventually obtained the judgment against the Republic of Kazakhstan. And as far as I know, they're still in the process of enforcing this judgment. I think one interesting aspect of this case is that one of the defenses raised by the Republic of Kazakhstan was a jurisdictional defense that the tribunal did not have jurisdiction over the claimants. The Republic of Kazakhstan also tried to raise the defense that the claimants were involved in fraudulent activities. And they actually proposed to the court to consider evidence of certain alleged fraudulent activities that relating to the claimants. However, the court rejected this evidence, saying that it's just too late, because by that time the award has been issued, and it just the state was just did not present timely its evidence of alleged fraud. Another interesting case is Tatneft versus Ukraine. In Tatneft, Tatneft is a Russian company that obtained arbitration award against the state of Ukraine. And it went to the United States to enforce this arbitration award against Ukraine. And one of the objections that Ukraine raised, that is actually quite interesting objection, is that the Tatneft was not really investor in Ukraine, because Tatneft was owned by the Russian government, and the investment state dispute resolution system exists to protect interests of private investors, not the interest of investors that are owned by foreign states. My understanding that was the argument that was also raised by Ukraine in the arbitration itself, and was raised again in the United States court. But the United States court said that basically that arbitrators consider this argument, and they rejected this argument, and so U.S. court would not review the arbitrator's findings in that regard. And that's, by the way, that's a typical approach that United States courts take, and that's why enforcing of arbitration award is especially valuable in the United States, is because U.S. court will typically not look into the decision of arbitrators, even if this is not only on the merits, but also on the decision on jurisdiction. There is a concept, of course, there is a concept that arbitrators, if the parties agreed that arbitrators have the right to decide their own jurisdiction, then the United States court will defer to the arbitrator's decision.
Are there other legal tools particular to the US that claimants use in the enforcement proceedings?
I think the most important tool that claimants use in general, that exists in the arsenal of legal proceedings in the United States is discovery. From what I understand, discovery is rather unique US proceedings where the parties to legal proceedings, the court proceedings, have the right to request documents from, of course, from the other parties, and that exists also in other countries as well. But in the United States, that is especially a powerful tool because the discovery requests are generally more broad in the United States than in other countries. Moreover, in the United States, parties may have the right to request documents, to subpoena documents from third parties as well, not only from the parties to legal proceedings. And the courts typically allow this type of request. They're open. These type of requests are provided by the rules of civil procedures in US courts. So that is a very powerful tool. What's interesting is that even in light of the foreign sovereign immunities, the claimants may have the right to request documents that have information about sovereign assets in the United States and also all over the world. The discovery is also very powerful because the failure to comply with discovery requests could result in significant sanctions. For example, there was a case in New York where there was a claim against a Belarusian company, Belneftehim, and the court allowed discovery, and it was not even discovery in aid of execution of the judgment. It was discovery at the preliminary stage to determine whether Belneftehim is a state-owned company or not. And the plaintiffs they requested documents and information and subpoenaed the company to provide these documents, which the company just simply ignored. And eventually, after several rounds of motions and orders by the court to produce this type of information, the company simply ignored and refused to do so, and the court imposed fines in the amount of almost $2,000 a day for failure to produce responses to discovery. That is why it's very important to consider that if you're a claimant, and also, of course, on the side of the defense, you represent a state or a state-owned company, to understand what are the responsibilities and what are the proper objections to such discovery.
Is there a role that third-party funders play in the enforcement proceedings?
Well, absolutely. Third-party funding is legal in the United States. There are certain limitations and there are certain considerations that needs to be taken into account, but there is a pretty significant and broad market for third-party funding for the enforcement of arbitration awards in the United States, and especially and in particular, the arbitration awards against foreign states. And the third-party funding can kick in not only at the stage of arbitration, but even after arbitration was already completed, and the claimant has an award. And in order to enforce the award, the claimant needs to get additional funding, because, of course, litigation is unfortunately, or maybe not, but it's not an expensive enterprise. So third-party funding is an important consideration. Now, there are certain, as I said, there are certain limitations there, and there are certain considerations that need to be taken into account. And one particularly important consideration is attorney-client privilege. Attorney-client privilege in the United States is a very important concept, is a very important idea that protects communication between attorney and the client. So if, for example, client discloses information to third-party funder, it needs to be the special agreements and the special documents that would need to be prepared to make sure that this information does not lose its privilege. So it's just lawyers that need to be aware of that, and then parties as well.
And now we are switching to my favorite part of the interview, the most intriguing part of the interview, of 10 honest, quick and honest questions and answers. And my first question is, why did you decide to get involved with the international disputes?
I got involved in the international disputes by chance, but then I fell in love with this area of law. And I think the most important to me is the ability to be exposed to international cultures, to different views from different lawyers from different countries and jurisdictions, and to see how these different jurisdictions approach the same questions from different perspectives. I think it's just fascinating.
What advice would you give to a young lawyer who is inspired to build a career in international disputes?
Most importantly, learn by practice, not by the book. If you want to get involved in international dispute, do it early. Go to conferences, get involved in the preparation to the conferences, do the practicums, do the internships, get involved in the legal organizations and associations and club. Show your interest, show that you're interested, not simply tell, show, but not tell. That's important.
What is the most challenging part of being a lawyer?
I think to me, the most challenging part to be a lawyer is to be able to convince the client to do what's in the client's best interest as what is my legal responsibility as a lawyer.
How do you define success?
Paraphrasing Thomas Edison, success is 1% inspiration and 99% perspiration. So just hard work. That's what success is all about.
How did COVID impact the practice of law?
I was actually surprised how technology got implemented during the COVID time, especially this video conferencing, which is what we're using right now for our interview. I remember only a year ago, if somebody would say video conferencing to my colleagues in somewhere in other countries, some would say, we don't know what it is. Let's just talk on the phone. Let's just do this. Let's just do that. But now everyone is using video conferences. It's just absolutely amazing. So technology is the first and the foremost result of this COVID, of course, of this COVID situation, as far as legal profession is concerned.
Where do you see the practice of law developing in the next 10 years?
Well, I believe that technology will develop even further. And especially the new technology that relates to blockchain and artificial intelligence. And the traditional law firm model where you have physical offices with lawyers in it and associates in it probably will diminish even further. I believe that more and more firms will adopt the distributed law firm model or some type of distributed or some type of hybrid distributed and traditional law firm model. It's just a different way to practice the law and delivering legal services. And I just believe that it will eventually replace all the traditional law firm.
What is the most memorable case in your career?
I think the first case was my most memorable case. I was a newbie lawyer. I was 2 years out of law school. I didn't know anything about international arbitration. And I was asked by my client, can you help me? You're a lawyer, you can do that. I said, I don't know. Well, fortunately, I had somebody who had a tremendous experience in international arbitration who helped me in this case. And it was an exciting case. It was actually in Switzerland. It was my probably first time that I went to Switzerland. And I think it was amazing how it just went. It was successful. It was a lot of work. It was a lot of work. I had to go over review thousands and thousands of documents, and I was essentially by myself who was doing that. And eventually we found this one-page document that eventually decided the fate of the case. Just one-page document that decided the fate of the case. And we've been successful, and everyone was excited about that. That was my first and probably the most memorable experience.
What is your hobby?
I like sailing. I like the strength of the wind. I like the breeze. I like the quiet power. Maybe not, sometimes not very quiet, because sometimes it can get pretty loud when you're in the wind. But no motors, no engines, just the natural power of the wind. I love it.
Where you would like to travel when pandemic will be over?
Oh, my favorite destination is Antarctica. I'd love to go to Antarctica. It's just a fascinating place. Never been there, and that's certainly one of my bucket list.
What is your favorite movie?
I don't know if younger generation saw this movie, but it's a Moscow on the Hudson with Robin Williams, where he plays a Russian saxophonist who went with his band, with this orchestra, to America for the tour to the United States, and it was back in the 80s. And he, during his visit to the Bloomingdale's, which is huge department store in Manhattan, he defected. And when he defected, he was standing and watching his friends living in the bus, and he was on the street by himself. And then journalists surrounded him and started asking him what he's feeling and what he's doing. He said, "I'm happy and I'm free." That's I think that's the most memorable movie and the most memorable episode from this movie that I love.
Thank you very much, Jean. Thank you very much for your honest answers, and that you tell us not only about your professional experience, but also open up a little bit your personal life.
Thank you very much, Anna. Appreciate your hosting me on this program, and all the best.